Hi everyone, Assalamualaikum warahmatullahi wabarakatuh. In this video, we will discuss on the legal requirements and Shariah issues in Tawarruq. We are going to focus on the implementation of Tawarruq, particularly in the Islamic banking industry in Malaysia. So first, let's start with a brief background of Tawarruq. In the 1990s, at the beginning of Islamic banking industry in Malaysia, Buy-Ina was a well-known Islamic financing product in their practice. However, due to some arguments made by Islamic jurists, they unanimously agreed to introduce Tawarruq as the alternative to Buy-Ina. And since then, most Islamic financing products are predominantly based on Tawarruq. And currently, Tawarruq also known as commodity murabaha. For your information, there are two types of Tawarruq, which are classical and organized. So the differences between these two types is the implementation of dual agency in organized Tawarruq. And to conclude that according to BNM 2016, financing-based Tawarruq rose about 34% of overall Shariah compliant financing product, and this number continuously grew.
So, a Tawarruq consists of two sale and purchase contracts. The first involves the sale of an asset by a seller to a purchaser on a different basis. Subsequently, the purchaser of the first sale will sell the same asset to a third party on a cash and spot basis. So, what is the nature of Tawarruq? So, it is binding in nature and shall not be terminated unilaterally by any of the contracting parties. And then the common inherent nature of each sale and purchase contract in Tawarruq is the transfer of ownership of the asset from the seller to the purchaser for a consideration. And it is also stated in the PD that the contract in the Tawarruq may take in the form of murabahah or musawamah. Alright, so the concept in Tawarruq is actually an act in purchasing a commodity for a delayed price and then selling it to a third party for a spot price to obtain the immediate cash. So there are similarities and also differences between Tawarruq and Buy-Ina. So for the similarities, first, the purchaser in the first sale and purchase transaction is actually in need of cash. The first sale and purchase transaction is in deferred mode. And lastly, the second sale and purchase transaction is in a spot cash for both Buy-Ina and Tawarruq. For the differences in these two contracts is that in Buy-Ina, the whole transaction process involves only two parties, while in Tawarruq, they consist of three parties.
So, what are the legal requirements for Tawarruq? According to the standards issued by BNM in 2018, all sale and purchase contract based on Tawarruq must fulfill all conditions under Shariah for it to be valid. And all transactions must be conducted through a separate and independent contract and must be presented by verified documentation. As for the purchaser has right to take the delivery of the commodity and shall not be forced to sell the commodity to other party. For the payment of deferred selling price and profit shall be made after parties enter into the contract, not before. And all these standards have been issued by BNM in the policy document of Tawarruq.
So these are the Shariah requirements for Tawarruq, where it shall be clearly outlined between the IFI and the customer, for example, for the purpose of deposit taking, provision of finance, or even derivatives. And that the contracting parties in the Tawarruq shall involve at least three parties, which consist of customer, the IFI, and the asset trader, for example, the Bursa Suk Al-Sila. The third one is offer and acceptance, where the IFI shall specify the date where applicable, the frequency of when the offer and acceptance of the first sale and purchase contract shall be executed, for example, in the case of financing at specified disbursement dates or in the case of deposit at a specified rollover date. The fourth one is the assets, where the IFI shall specify the asset to be traded in line with the requirements in the PD, where, for example, it can be objectively valued in the open market. And lastly is the price, where the selling price in the Tawarruq shall consist of the acquisition cost of the asset and profit as being stated in the PD.
Next is operational requirements. They are governance oversight, risk management, business and market, as well as financial disclosure. So first, we are going to look at the governance and oversight. They are for board of directors, Shariah Committee and senior management. So board of directors must ensure that IFI comply with the legal and regulatory requirements on the application of Tawarruq, as I mentioned before. And for the Shariah Committee, they must advise IFIs on any matters related to the Shariah, such as Shariah rulings, Shariah decision, and Shariah guidelines. For senior management, they should undertake regular reviews and monitor that IFIs carry out the application of Tawarruq with approved policies. Next is risk management. The management should identify and monitor risk exposure on the application of Tawarruq. And if there is any risk on the application, they should exercise risk mitigation techniques which in line with their risk appetite. For business and market, IFIs must ensure that all fees and charges, description, nature and features of Tawarruq are accurate. All terms and conditions of asset acquisition, sale of asset and others are in accordance with the Tawarruq purposes. It should be matched. Last but not least, financial disclosure. They must report and record all transactions in the financial statement, and it must be on a timely basis. All transactions must be fair and true.
So these are the operation and application of Tawarruq in IFI. So the first one is the property financing or home financing, where the transaction where a buyer buys property on a deferred basis and subsequently sells the property to a third party, which is a bank, for cash at a lower price. The second one is the personal financing, where the bank will purchase commodities from a supplier as a first sale on a spot basis and then sells them to a customer in the second sale on a deferred basis. And the third one is the deposit account, where the Tawarruq concept becomes an alternative and achieved a really wide usage as underlying concept in Islamic deposits. And this is actually a new product which complies with IFSA 2013.
Last part is the gap analysis. We will look at different views between BNM and AOF on two matters, which are dual agency and asset use in the Tawarruq transaction. For dual agency, BNM permits the bank to be appointed as an agent to resell the commodity on behalf of the purchaser to the third party. However, this is in contrast with AOF Shariah standard that prohibits such appointment. According to AOF, they only allow purchaser to resell the commodity through agent other than its institution. So, in the Islamic banking industry in Malaysia, the contract based on Tawarruq transaction is not be considered as invalid as long as the implementation of dual agency does not lead to injustice.
So the other analysis is where the BNM policy stated that the asset being used can be intangible asset or a tangible asset, while AOF stated that the asset must be a real commodity that the seller owns before selling it.
To conclude this video, Tawarruq is the most used Islamic banking product in Malaysia, and despite of the issues on dual agency and asset use in the transaction, Tawarruq eventually provide maslahah to the customer as it fulfills their needs of needing immediate cash. And that's all from me and Alia. We hope that you will get the benefits from this discussion. Thank you.